Welcome back, ladies and gentlemen, to the Layman's Law School, where three Southern gentlemen lawyers sit around and discuss the legal issues of the day, hopefully in layman's terms, in a way that you can actually understand. Today we're going to be talking about, we're going to give you a couple updates on some of the cases we've discussed in the past, and we're going to talk about, believe it or not, my wife's hall pass, Justin Timberlake, and his recent legal issues.
A little hodgepodge for us today.
A little bit of a hodgepodge.
Update that. I mean, he definitely didn't bring sexy back anymore.
Wow.
We're bringing sexy back today.
Oh, okay. I'll let you do that. I'll let you handle that, Sean.
All right. Well, before we get started, Jay,
yeah, let's begin the unfortunates. Yes.
The unfortunate.
We celebrate another
It's been a
beautiful Friday.
Beautiful Friday. A little rainy, but
we're still in business.
Bud Light has made a comeback. Shane Gillis is now their spokesperson.
I mean, so all you guys out there who quit on me,
Mm-hmm.
And those people in the
I never quit. I just never started.
Right. I'm just saying, all these people are owned by the same thing. So all the people in the comments, whatever you're drinking is the same thing.
Anheuser-Busch.
Black Rock.
Mm-hmm.
Anyway.
Yeah. So first and foremost, to give you a quick update in the Karen Reid trial. This, of course, was the woman that was charged for the murder of John O'Keefe back in January of 2022. Her case went to trial, and basically there was a mistrial, and it turns out that some of the jurors reached out. They asked to remain anonymous, and they basically stated that they had reached a unanimous verdict on counts 1 and 3 of the indictment, and based on that, the defense filed a motion to dismiss based on the Fifth Amendment prohibition against double jeopardy.
Sure.
And the judge heard that motion and has ruled against them. She's ruled against them based on what I do believe is some formalities, but I mean that's her job is to apply the law, and basically it's that there was no formal declaration of acquittal on those particular charges in court on the record as required by Massachusetts law.
I think she's right on that. I mean, I don't think there's a difference between being what's right, how you feel, and what is correct in the law.
Yeah.
Well, that doesn't mean the law is correct.
No.
Sure. It just means I think that she made the right decision as far as applying it.
Mm-hmm.
That's
and I know, Chase, you probably saw the actual moments in the trial when all of that occurred and what the announcement from the court was, any interaction that they had with the jury or the jury foreperson. And I'd be curious to know what happened because, in Georgia, when any case that I've had that's been a mistrial, the judge is essentially asking the jurors, are you unable to reach a unanimous verdict as to any counts of the indictment? Sure. And when they say, yes, we're unable to do that, well, that, if that was the question to this jury, either the foreperson said something incorrect or these people thought after the fact, well, we were pretty convinced about this, but that's really the standard for a mistrial on a hung jury, is that they are unable to reach a unanimous decision on any count.
And the reason I kind of think that you have to do it this way is there could be a quiet voice in that jury room that, because it was a holdout on another one, just kind of went along with this because it knew it wouldn't be over, where they may have stood up. So you want it beyond a shadow of a doubt and all that, and so I don't think it was proper to grant that either.
Sure.
I think that the real error came from the form and the way that the jury form, and the way that it was presented to the jurors. That's where the error started. I mean,
sure.
Which you can't fix until post a new trial, prior to a new trial.
And that's one of the things that the defense actually won out on, is that there was an acquittal section where the jury could just say we acquit her of all charges or we find her guilty, and they said no, we need it separate on each count. Yeah. They argued that motion. They eventually won that motion. They changed the jury verdict, but I think one of the things that...
It still was not the way you would really want it, in my opinion, because it still alluded to charges being together and having to have one without the other, and that's not really the way it should be.
Yeah, and it all played out. You're starting to see why this became an issue. And Sean, to your point about, on any of the charges, none of that language was actually used in open court. It was just, are you able to reach a unanimous verdict? No. Continue to continue to deliberate, going back and forth, and multiple times, and then eventually just saying, no, we can't come to a unanimous verdict. No polling of what about the individual counts, nothing like that. But
the only polling I saw was that they polled and said, is it true that you can't come to a
unanimous verdict?
That's it.
Yeah, and the other thing that hurt the defense's argument is they consented to a mistrial. And in Massachusetts law, if you consent to a mistrial, it's basically consenting to being retried.
Yep. Sure.
And so for that reason, it was denied.
But then at the same time, people might say that's a mistake by the defense. Mm-hmm. It's not. You got a mistrial, you got to take it.
A mistrial is a win.
So
it is not a conviction.
They could not risk going, no, we're not going to do that. Mm-hmm. Or, there's no way.
No, I mean, a mistrial when you're facing murder charges is an absolute win.
Yes.
And, I've been in the position of, trying a case for almost 3 weeks and the jury being out for several days.
Yep.
And finally, explaining to the judge, they've told us numerous times that they can't make a decision.
Yeah.
At this point, we are holding them hostage, and we're going to get an unjust result if you hold them hostage and you're forcing them to make a decision.
Yep.
It's going to be unjust one way or another, whether it's not guilty or it's guilty. Some people are going to be forced into making that decision.
I mean, if I'm sitting in there, or you're sitting in there, and we got young children, sooner or later, as much as you don't want to admit it to yourself, you're probably going to cave.
I want to go home.
I didn't commit anything, so
right.
Anyway.
Yeah, so and because of that, what's most likely to happen, and I think this has already occurred, the defense team's going to appeal to the Massachusetts Court of Appeals, and then if they fail there, or it may be taken up directly by the Massachusetts Supreme Court. And because this is a constitutional issue, okay, they could have a writ of certiorari to federal district court or to the actual Supreme Court to make a decision on this based on the facts and circumstances.
And in layman's terms, what is this writ of certiorari?
Okay, yeah. So the ultimate authority, the main judge for any legal right that is enshrined in the Constitution, right, is the Supreme Court. They decide and interpret the Constitution.
The United States Supreme Court.
The United States Supreme Court, that's right. And so if a state is applying their law and to their laws and it affects a person's constitutional rights, you as that citizen, even if they apply Massachusetts law absolutely correctly to the letter, exactly how it's supposed to, but the Supreme Court finds that violates your constitutional rights, that changes Massachusetts law and invalidates the rulings. It changes the law for a lot of states if they have laws like, or common law or statutes like Massachusetts. So I'm interested to see how this plays out. But
and to answer the question, the writ of certiorari, it's not really.
Sorry.
It's simply asking the United States Supreme Court. You're saying, hey, I have an issue. It involves constitutional law.
Yeah.
Here is the issue, and we would like you to hear it.
Yeah.
And they either say yes or they
say
can no.
Choose. Yeah.
It can be one sentence.
No.
Cert denied.
Denied.
Or it can be writ of certiorari. Is accepted, and you start doing briefs and all that stuff.
And they're only going to take up stuff that's not controversial but unclear.
Yeah, sure.
So it's like we've already decided this. In these cases, we're not taking it up.
But so for me on that is the point on the Karen Reid situation. I do not believe that she will ever be tried again.
I certainly hope not.
I don't think so. They immediately said yes, she will, and I think if we played the tape back, I said I don't think it'll happen. I'm more positive in that situation now.
Reid, the soothsayer Sanders has
struck again. Struck again.
Well, we'll check up in January 2025. It's currently scheduled.
0% chance. You may be talking about January of 2035, if they have any chance.
Right. Okay,
By then, we'll have at least 5 million subscribers.
Easily.
Yeah.
I mean, there'll be 200 billion people on the earth, but we'll trick a couple.
Especially if you're being sexy back like you talked about.
He ain't got his suit and tie on.
Very good. All right, so moving on to the case we discussed in the last podcast, a Disney lawsuit. This is a wrongful death lawsuit that involves Disney, where they tried to argue that the actual plaintiff in the case, who was the husband of a woman who passed away due to being served nuts in a dish that she asked the staff about. It turns out that Disney is basically they lease out this property to another business that runs a restaurant out of there. She asked about the nuts, whether or not they were in the actual dish. They assured her that it wasn't, and of course there were, and she passed away. Well, Disney has argued in court, or was arguing in court, that the arbitration clause contained in the Disney Plus subscription that the husband signed up for temporarily 3 years ago applied, and that he had to arbitrate and didn't have the right to the actual court system. Well, update is that PR pressure.
That's it.
And we talked about this in the podcast. Yep. PR pressure, because this is a black eye for them to try to deny a person's right to being taken into court, right, based on something.
And as we said, that's not their
arbitrary.
best argument either.
No.
I mean, they got a slam dunk argument essentially, but anyway.
Yeah. So ahead. But you said weak legal argument. Explain that. What are you talking about?
We always talk about it as standing on high ground, right? And I mean, I'm just talking to y'all, but we talk about it all the time. You may have a case that that you're looking at, and you have to get your case over the duty, right? The other person has a duty. We have to cross that, and we look at it, and we can do it 5 different ways. And one way is it could go either way. So it's, there's 2 or 3 that are kind of like pretty good, but there's still a little bit of things that look bad on you, and then there's one that you're completely
unassailable,
you're completely perfect at, right?
Yeah.
And so don't bring in all the other trash. If you have something that is, you win the game. There's no sense in bringing in these other arguments like this that just kind of taint your case, really.
Yeah.
Where Disney has a great argument of that they aren't really the person that's responsible. They can stand on that forever, and they're right.
Right.
But
it's just their property, and they leased it to somebody else.
That's it. Don't bring yourself into a situation. They probably have a good argument with the arbitration clause, but it's not one that you even want to make. It's just not standing on high ground. It's fighting in the mud. It's not fighting up where you have the upper ground.
Right. Yeah, you're already a corporation versus a dead woman.
Right.
Right. Or a widower.
Sure.
Is that what you call them? Yeah, widower.
Widower.
Yeah, a widower. And so you're already going to be looked at as in a certain way, and then if you try to get out of any, you try to take anything else from them,
and
it's going to look bad on you.
Technicalities.
Yeah, technicalities.
People know that's not a decision made on the facts of the case.
Yeah.
That's a decision made on a technicality where a big corporation has high-powered attorneys
take advantage,
and they're taking advantage of another person.
And
you're going to win on another argument. Don't do that one.
It's a situation where attorneys are doing their legal job, but not consulting with the client probably about
They're doing the client a disservice.
If they would have just said,
okay,
we understand you have filed a lawsuit against us, but we're not responsible because this isn't our restaurant. We just leased the property to them. We have no oversight, nothing.
Yep.
It would have never made the news.
No.
And they wouldn't have had bad, public, bad publicity. But when you come out with, something so minuscule and something that everybody thinks is unconscionable.
Even if you're right.
Yeah, even if you're right, it obviously, hits them where they see that they're getting this negative publicity, and they want to hush it up, and they say, "Oh no, we're dropping that."
Right.
Well,
yep. And they still won't pay anything because they're not going to be responsible. But this is, like you said, Chase. It's all the public forced them to get out of that because they made a decision, and I'm glad. I mean, they shouldn't be allowed out on that, and it's garbage.
Yeah.
And the public stood up and made their voices known. You know, that's how you can make change in some ways, especially with these corporations.
Well, and we actually have an employee who's heading down to.
I know, and I talked to her today.
Disney,
and she
World.
wants to do when this has a follow up.
Mm-hmm.
She wants to be a sit in and wait. She's going to give her opinion on the app and how it worked and all that. So anybody out there at Disneyland, Disney World, whatever, you might want to log on or try to pay us a lot of money to not get her on. Let's see.
I'm just glad that she doesn't have any food allergies that I'm aware of.
Yeah, I asked her about that, and that was one of her topics. I'm not going to ruin it though. We're going to save that for another episode because there is a legal thing. Disney, watch out.
All right. Well, staying with Disney a little bit, Justin Timberlake, he was a Disney product.
Absolutely.
Yeah. Justin Timberlake back in June of 2024 was arrested in Sag Harbor, New York. I think that is the Hamptons area.
It definitely is the Hamptons area.
Okay.
And did we do a podcast on this before, or was it just a topic that we thought
we
might
thought
do?
about? Yeah.
So we're not bringing sexy back. We're bringing sexy for the first time.
All right.
And number one, why would Justin Timberlake ever be driving his own vehicle? I just don't. I don't understand it.
He's trying to take back the night. It's 12 o'clock. It was just he was out there summer loving.
Oh God! All right, so
tunnel vision. Once you get a couple drinks and you get that tunnel vision, you get your keys, you think you're good to go.
Reid, it was one martini.
One martini, exactly. So he ran a stop sign, was swerving in to the oncoming lane, according to officers. When he was pulled over, the officers noticed he had bloodshot eyes and smelled of alcohol. Apparently, that was a very strong martini.
It'll rock your body.
Right, yeah.
Well, let me just tell you this, coming from my experience.
Mm-hmm.
You're a big martini
guy.
No,
not my drinking and driving, and not my drinking. Y'all know I was a police officer for 12 years.
Mm-hmm.
Several of those years I was on road patrol, work nights, and arrested a lot of people for DUI.
Sure.
When you are not drinking and not around alcohol, like you weren't even at the restaurant, you weren't at a bar, even if you're a sober driver, when you're a police officer and you're not drinking, not around alcohol, and you pull over a car and they roll down the window, you immediately smell alcohol, even if they've had one. It's just it's something that you're not around.
It's kind of like cigarette smoke. It's just on you. It just kind of gets on you.
Yeah, I'd be interested to see if we did some tests with that. It's like if you smell what you're expecting to smell, or smell, what I mean? Because you often can play a sound and you think you hear one thing being said, and then if you write words up there that's something
green
else,
lantern?
you'll start hearing. Yeah.
The famous one, the green lantern, or the other word I can't remember, but it's something lightning and green.
Yeah.
Whatever
if
you read, you hear.
Yeah, so I'd be interested to see if they could do some tests with that. But yeah, they smelled alcohol, and then they asked him to do a breathalyzer test, and he refused. Now in New York, there's something called implied consent law,
as in Georgia.
Right, yeah. Can you explain to the viewers what implied consent is?
It essentially means that as a condition of you having a driver's license in that particular state, you are giving implied consent that you will subject yourself to testing of your blood, breath, urine, other bodily substance for the purposes of determining if you are under the influence of alcohol or drugs when you're operating a motor vehicle and the police officers have probable cause that you are operating the motor vehicle, under the influence. That's what it means. It's essentially, they state it, and they state it correctly, that, driving on the roadways of a state with a driver's license is a privilege.
Right.
And that privilege...
Right. It's not a right.
That privilege comes with you providing informed consent or implied consent that you'll consent to these things. So... in Georgia, you're agreeing to that when you get a driver's license. Then when you're pulled over and suspected of DUI and they have probable cause, they're normally going to arrest you for DUI, and then they're going to read you your implied consent rights that basically says, Georgia law, says that we can take a breath sample or a blood sample. Will you submit to this test?
Yeah.
And then you can either refuse or you can submit. And obviously,
Well, if you refuse, I guess it's just cry me a river, right?
Well, if you refuse, there's two different things going on. There's an administrative side that has to do with implied consent, and there is a criminal side. Obviously, if you refuse, there is not going to be a sample. There's not going to be any evidence of what your level of intoxication was unless they got a search warrant,
right?
And forcefully took your blood.
And explain to the jury, because this shocked me.
And it's different than it used to be too.
Explain to the viewers,
But it wasn't always this way, so it definitely has changed. I mean, as far as them, the state being allowed to pull blood, that's
sure.
I don't know, 5-10 years ago, whatever.
Yeah, explain to the viewers, like in Georgia, what the law allows for police to do with regard to like drawing blood from you, even if you refuse.
If they have probable cause, they can go to a judge and get a search warrant for your blood and strap you down and have a medical technician take your blood from you.
Yeah.
That's all there is to it.
And you say that, hey, you're going to have to go to a judge and blah, blah, blah. These things are rubber stamped quick.
Yeah.
Sure. I mean, and they have to be, if you're going to do that, you're not going to, it's not a situation where you're waiting until 9 a.m. to get a judge on the bench and then you ask him to get something. It's, there's somebody on duty ready to do that if necessary.
Absolutely. Well, and it's not, at least around here, it's not used very often.
Yeah.
Speaking. I mean, in a fatality accident,
absolutely,
they're going to use it. In serious injuries accident where it's suspected DUI, they may very well use that. But in the cases that I see people coming in the office, cases that I look over or talk about with other lawyers, the law enforcement officers in this area generally are not doing that.
Yeah,
they are relying on which we'll talk about what Justin was charged with versus what he is going to plead guilty to. They're relying on the fact that I don't care if I have the evidence that you're above a certain limit.
Yeah.
I can testify, and my evidence and testimony is going to be that you were impaired and a less safe driver because of alcohol.
Right.
And that's all I have to prove. I don't have to prove that you were at a certain level.
Sure. And some states don't have the less safe law, which Georgia does, obviously, which helps that situation. I think having the less safe is some states that don't have that, the police officer is going to feel like it's mandatory for them to have to take the blood because there's not a lesser charge that carries the same weight, but they don't have a charge that's different.
If the element is that you have to prove they're above 0.08 or 0.1 or whatever the limit is,
and they refuse,
well, there might be some administrative issues with their driver's license suspension, but there's no way you could prove that case in court.
Yep.
Yeah, and I think that might be, why we don't want people to get away with being intoxicated and driving around. It might be, like in this particular case, the defense team was able to argue, and the prosecution had no way to refute that he had one martini.
Yeah,
right.
Right? And so anything a jury would hear about whether he was driving intoxicated or not, the only thing they would be able to hear is that he had one martini. There's no blood alcohol test. There's no breathalyzer, no nothing. And so that would devastate any prosecutor's case against him for that. But that does come with consequences, right? So automatic license revocation.
Sure.
And in Georgia, it was for 1 year, right?
1 year, and you have no ability to get any type of permit to drive. Not a work permit, not to drive to and from school, to and from work. It's just what they call a hard suspension for 12 months.
Right. So he was charged with DWI, which is just driving while intoxicated. And recently he pled guilty to driving while ability impaired. Okay, I don't think we in Georgia have something like that.
We actually do. Excuse me. I looked at the New York laws, and they are strikingly similar to Georgia. In Georgia, we have one DUI law that has different ways that you can be found guilty of DUI. Number one is the per se rule, and that's Georgia as well as New York have the same per se. Per se meaning that no matter what the evidence is, if you're above this limit, you are by statute driving under the influence.
So it's I get this a lot too. If you have that evidence, and that there's even with my kids, it's they give you a lot of reasons why it happened. It doesn't matter.
It doesn't matter.
It doesn't matter.
It doesn't matter.
It can be. You might save the world. You might save the earth if you did that, but it doesn't matter. It doesn't matter.
Well, and that's the thing is that there's no perfect way for them to determine what level, but they use statistics, and the National Highway Traffic and Safety Administration, uses statistics that the average person at this level would be impaired. Now, there might be
you can't make you can't make the argument that I can do this and somebody else can't. I'm a good driver. I can show you I can do it. Those arguments are out. They're not even they're
not valid, even though they might be true.
Right.
Somebody could be.
They're not even allowed to say them.
Yeah, I'm fine at this level. I'm fine after 5 beers.
You could even prove that. But a jury would not be allowed to hear that because it doesn't matter. It's per se.
So you have per se, which New York and Georgia is at 0.08. Yep. That's the legal limit, and that's in most states. They've adopted that. And then in New York, they have the driving while impaired, which is simply the same thing as in Georgia, which is called less safe.
This is
it's just you're not 0.08, but you have an amount of alcohol in you, and because of that alcohol, you are a less safe driver.
Or drugs or whatever.
Oh yeah, sure. But they have to show other things in order to prove less safe. You have to show not just that they had alcohol in their system, but that they were a less safe driver because of it, that they, committed some infraction.
I think on Timberlake, he ran a stop sign or something.
Ran a stop sign and swerved across into
those two things. And you can do that. Obviously, you can do that sober, but that is evidence that he was impaired in some way. So.
And what running a stop sign is subjective a little bit.
Well, I saw,
I didn't see the video.
There's no video of him running the stop sign that I'm aware of. There's body camera footage that has not been released yet. There's some footage of him actually traveling through the downtown little area where they were at, and he was driving fine from what I could see. But I saw news reports that he blew through a stop sign, and then I saw news reports that he
California
rolled through a stop sign.
Yeah, that's what they call it, California roll.
But the officer also indicated that he was failing to maintain his lane, which I know that's a very subjective type thing. If you get behind any car driving any time of the day of an unimpaired driver, at some point the police officer could pull the person over because they touched the line, went outside the line, so that's a standard thing that you see in a lot of DUI arrests. But when you get behind a real DUI driver, you can really tell when they're failing to maintain lane.
Absolutely.
Because they're all over the place.
Right.
Yeah.
It's not one little mistake. It's usually numerous, and
it's a struggle to keep it on the
road. Yeah.
Well, in pleading guilty to this lesser charge, he was fined $500 and ordered to do 25 hours of community service and 90 days license suspension. And he agreed to appear and make some public service announcements, I guess, about driving while impaired. How does that compare with what you would normally experience with regard to a DUI in Georgia versus New York?
Well, I can answer one thing for Sean. I was going to 2 things. It's a lot cheaper in Georgia. Your license would be bye.
Oh
yeah, your license would be suspended depending on if this is your first DUI or second DUI. There's different things. How long it's suspended for. You can also get the I got the bye.
Yeah.
I'm just trying to actually provide the public with some
actual
information.
He's the color man. You're actually commentating.
Listen, I'm trying to throw you some good softballs up there.
There is the ability for you to get permits depending on the case
with all this
to drive to and from work, to and from school, things like that.
And seriously, in Georgia, you have most of them have. There's a maximum amount of time you can be out. Like there's different limits on that, right?
Oh yeah, it depends on whether or not for license purposes, whether or not you've had a DUI in the past 5 years. For criminal charges purposes, whether or not you've had a DUI in the past 10 years. Yeah. Things like that. But generally, first time DUI for a person is going to be 24 hours in jail. The fine is going to be $1,000 plus a bunch of surcharges. It probably cost you $2,000 something in fines. 40 hours of community service. You have to complete a risk reduction course, which is a DUI class,
which also is not cheap.
Another $300-$400 right there. Possibly a clinical evaluation where they make a determination, a counselor, whether or not you have a alcohol dependency issue or something like that and need counseling. So there's some mandatory terms in Georgia that no matter what,
much harsher.
That's the sentence. There's no getting around it.
I'm curious on this, and I don't know, obviously, but some of the sentencing was, if you're going to give that light on one side, it was heavy on the other, which I find interesting, and maybe it's because it's Justin Timberlake. Like, normally you're not giving a whatever it is, $500 fine, something very inexpensive for him, and then giving 20, 30 hours community service. Mm-hmm. Usually it's flipped. And I think what the judge is thinking, and I would agree, would be if you want him to have to suffer any punishment, you can't fine him enough money because there's limits on that. Yeah. I don't know what New York's are, but I guarantee you it's a penny to him, right?
Oh, absolutely.
So the only thing you can really do for him or to make him appreciate what he's done is
force him to be there.
Take away his time, And so that community service is the real the punishment, so to speak, or the real hopeful change in attitude, so he doesn't feel so justified next time he's riding around like that. Yeah.
Well, and just think about it, the public service.
You got it in there, bud. You got it. That was good.
The public service announcements he's going to do, he is probably paying for himself.
Absolutely.
They're probably going to be on television in New York. So he's probably spending a lot more than $500.
That's what I'm saying.
The community
you're
service.
You're not going to hurt him with writing a check.
The community service, he's not going to be showing up to the Hamptons police station and walking around picking up trash with a bunch of teenagers. He'll do his community service at some nonprofit or something that he's affiliated with.
And there'll be meet and greets or whatever, and that's going to serve the community a lot more than him picking up trash.
Sure.
It's the good and the bad of having that celebrity is that he doesn't have to go in the muck like we would, but he might help a lot more people if he's upstanding talking to them too. So I understand it. It's just I do also want him to go have to pick up trash.
Me too, since he's my wife's hall pass.
Hall pass.
So,
it's all about what goes around comes around. You got to pick up some trash too, JT.
Yeah. Well, it was like 20. Was it 20-something hours of community service? 25 hours. He could do 2 concerts in that amount of time. So
I think if I was the judge, and I don't know
might actually
this
be,
I would have put multiple days, so you can't get them all in one day or all in 2 days. I'd have said you have to do 10 different things, and that's a judge can do that. They can say this can't be all in one day. They can tell you where you're where you have to serve your hour, so to speak, and you can split them up, which would, if I ever become a judge in New York City, that's what I would do.
Well, one of the things that I noticed about what the defense strategy when they were talking about in the plea deal and all that stuff and justifying everything, they talked about the fact that he wasn't belligerent, wasn't rude, aside from he didn't drink excessively, because they can't prove that, right? Yeah. And the only thing he didn't do by way of cooperating with the police was just say, I'm not taking the test, I'm not taking the whatever. Does that actually play a role in how and in the actual outcome of the case with regard to the judge and how the law is applied?
I would say absolutely, and most of the time the judges want to know how the officer feels about a case getting reduced. You were charged this person with DUI, and the plea bargain is, or they're asking for this case to be reduced to a lesser charge.
Right.
In Georgia, we are typically trying to get the case reduced to reckless driving, a non-DUI offense. A lot of times the judges want to know how the officer feels about it.
Right.
And that not being belligerent, not being an ass to the cop, not being, piss drunk, being cooperative, polite, everything. when a prosecutor goes and talks to an officer, you know, 9 times out of 10, that officer's going to say, "Oh yeah, this guy didn't give me any problems."
Right.
As long as it's not his second, third, fourth DUI,
Right.
The officer is usually going to be fine with, you know, I'm fine with whatever y'all do.
Right.
We'll catch him again in the future if he does this again.
Yeah,
and I think it also comes to the judges have not only. I agree with you talking to the police officer, but on the sentencing, sometimes you have cases that the state may not be able to prove to the DUI level, but can certainly prove to reckless. And then if that's the case, the judge is going to sentence it like a DUI.
Yeah,
You're going to get the penalties
Yeah.
of a DUI.
Yeah.
And so I think that plays into it too. If you have like you said, acting like a jerk, whatever, but also if you're refusing tests versus somebody who did the test and you have the same guilt, you shouldn't be this way. And you're not supposed to do it this way, but every person's human and every judge is too. They're going to give a harsher sentence to the person who refused versus the person who didn't refuse, everything else being equal.
Well, and that, you know, it really depends on what jurisdiction you're in. Because,
I'm talking about
there's jurisdictions around here that if there is a refusal, they kind of treat it like Justin Timberlake's case.
Right.
How are we going to prove the DUI?
Yep.
Like, there's no adverse consequences on the criminal side against the defendant for refusing.
Yeah.
And then there's other jurisdictions that, whether it be where you're having a case before a judge, like in a probate court, or whether you transfer it to and have it in front of a jury, that either that judge or that particular area of people, demographics of people in the jury, are going to say in their mind, he refused because he's drunk.
Yep.
You know, so there's that, you know, there's different places, and you kind of got to, there's no good advice to give to people.
Well, there's no one size fits all, because every county, every municipality, every state is different in how they handle that situation. You know, I know the tomb circuit my dad was in, they zero reduction on anything. And, you know, sometimes that makes them lose, but that was their policy. I don't necessarily agree with that. I think it's bad policy. I've told that to my dad many times, but you have other places that they will work with you on stuff and try to kind of get the middle ground. So, you know, when you see people on TikTok and all this stuff saying this is what you do, it might be right in some places, and they might be wrong in some places.
Sure.
So there's no right or wrong answer and all that.
I mean, the number one thing we always want to think,
simple.
you know, is it good advice to refuse? Yes, probably so.
Yeah.
You never want to give incriminating evidence against yourself.
Absolutely.
But there's consequences for that people need to understand. That, you know, a 12-month hard license suspension. That, you know, at least in Georgia, sometimes we can get around that. Sometimes we can have the officer drop that.
That goes back to how you acted with the officer.
Exactly. But that's a possibility. But then you have to think, if you had 3 or 4 beers and you were in fact DUI, I would much rather have a alcohol rating that says I was like 0.081 than have a refusal.
Yep.
Because a refusal, you know, in my mind, I think that, you know, prosecutors, judges, juries later on think that, he refused because he was
smashed.
Because he was drunk.
Yeah.
When with a 0.08 that's barely over the limit, you're going to have a lot better chance with an attorney of that attorney convincing the prosecutor probably to reduce that charge.
And some
you're
of that
barely over the limit.
And some of that is the what is it, alcohol sensor.
Sure.
You know, you can show that has a variance as well.
Yeah,
so,
there's
I mean,
dietary alcohol.
Yeah,
So,
all that stuff.
The takeaway for today, number one, of course, is don't drink and drive.
I mean, it's just bad news all around.
And if you ever have as much money as Justin Timberlake,
don't
drive at all.
There's
no point in it. I saw Justin Timberlake at the U.S. Open golf tournament in Farmingdale, New York. And he had like 4 guys with him that were giant bodyguards.
Yep. One of them can drive.
I guarantee you at least one of them could drive.
At least one.
And one of them was probably available this night that he got pulled over.
Yeah.
Just, you know, why would you risk it when you have that, you know, celebrity status and you have the ability to have somebody drive you around.
There's a lot of, most of us don't have that ability. That's what's so aggravating when you see celebrities have this kind of stuff. It's
we got to click on and wait on an Uber that's 19 minutes away.
But and then you got to pay for it. And it does cost money, but money to them is nothing. Come on, do better, be better.
And the second little takeaway, I guess, would be it can benefit you to refuse the actual breathalyzer, but it does come with consequences.
Absolutely.
So no, and then if you're going to assert your rights, to do it politely.
Nicely.
Sure.
Yeah, the whole goal of criminal law is to punish the wrongdoer and to reform the wrongdoer. And if you show deference to the law, if you show respect to the law, it shows that you are, even if you may have transgressed in some way, that you are showing respect to it and deference to it, and you understand that you have to abide by it. So when the judge sees that later, it's like, this is a person that's made a mistake, and I don't have to drop the hammer on him to make a point, right? So
it generally helps the entire situation, and not to change it because we're ending, but it's the same thing. Tyreek Hill situation. It's the same thing. The cop was 1,000% wrong on that one, but Tyreek obviously came out and said, I could have handled it better too.
Yeah.
And that's the truth. A lot of times it's just both sides, de-escalate. Don't make it worse. Just slow down, calm down. Everything's going to be okay. It's my zen moment to read right there.
Do you have a way to get...
I have so many more, but it's
like, for instance, if you're drinking and you eat strawberry bubble gum...
No, that's what you do. You choose strawberry bubble gum before you blow on the breathalyzer.
There you go, that's what I'm saying.
And I did want to know one thing, Sean. You're a past officer, so if you're behind me and I'm constantly checking my mirrors, does that give you cause or hesitation of any sort?
Well, I'm not going to be able to, at least at night, I'm not going to be able to see you checking your mirror.
But
what I will tell you is that, there are officers out there. I was never one of them.
I know you weren't.
If it's past midnight, like the statistics are that 80% of the drivers on the roadway have some form of alcohol in their system past midnight.
How?
So these officers would get behind a vehicle, and when people are actually looking in their rearview mirror, because
there's a car behind you.
There's a car behind you, and you've been drinking, so you're a little nervous and heightened. And the officer,
when I'm completely done nothing wrong.
The officer would actually go from side to side, so
to make you follow it.
It's with your
eyes,
peripheral vision. You know a lot more about that than me.
Yeah.
You are looking, and your car is actually failing to maintain lane because you're watching the car behind you.
Right.
And that's the thing about normally when we're driving and everybody is sober, you are looking well beyond.
Yeah, you're not looking in front of the car.
You're looking well down the roadway,
and
your peripheral vision is what's keeping you in line with the roadway.
Sure.
When you are intoxicated or very nervous because there's a police officer behind you, you are looking closer to your vehicle, trying to stay in the lines. That's going to make you actually do that. Or you're looking in the rearview mirror, and if it's a unscrupulous officer, he may be fading left and right to make your car, kind of mimic that.
I'll tell you this. My mom looks directly in front of her car. For years have passed and waved. She's never seen me once. And so when she's driving home Friday night from the football game, and it's going to be probably, midnight, completely sober, she's getting pulled over. Guaranteed.
Well, ladies and gentlemen, thank y'all for watching very much. This is going to do it for us this time. Join us next time.